Hello, and thank you for joining us for our webinar, Do's and Don'ts of FMLA. I'm Julia Goebel, Chief Marketing Officer at Benefit Express, and I will be your moderator today. This webinar answers questions surrounding Family Medical Leave Act, what employers can expect, and overall FMLA best practices in the workplace. This webinar will explore how to provide employees proper notice, which conditions qualify for FMLA, how to distribute a designation notice, what to expect when employees return to work, and when and why to extend an employee's leave. Before we get started, a few housekeeping items. If you missed something, don't worry. We'll be emailing you the recording and the slides after the webinar concludes. I'll be keeping the webinar muted to avoid any background noise. We will pause throughout for questions. Simply type your question in the GoToWebinar chat box, and I'll read it aloud for you at the end of each section. If we don't get to your question today, we will be sure to email you a response. And now I'm pleased to introduce our distinguished speaker. ERISA attorney Larry Grugin is our presenter today. With more than 35 years' experience in employee benefit law, Larry has a wealth of experience in dealing with qualified plans, health and welfare, fringe benefits, and executive compensation areas. Thank you for joining us today. We are delighted to have you. With that, I will now hand it over to Larry to get started. Let's take it away.
Thank you very much. I appreciate it. One thing is concerning about family and medical leave for many employers, especially those above 50 and maybe up to 200 or 300 employees. You don't have to deal with this on a regular basis. So every time anybody goes on leave, everybody scrambles trying to understand exactly what the requirements are. What I'm going to try to do today is explain what to do and what some of the do's and don'ts, because the problem is family and medical leave can be rather complicated, and that's the problem. So you have to remember exactly anything. The more you have written down, I think the more it would be easier to deal with it when somebody goes on leave and understanding exactly what to do. I think that's the challenge, because family medical leave is extremely complicated. So under family medical leave, certain eligible employees may take unpaid job protected leave of absence for certain family and medical leave reasons. Now, this is important because what family and medical leave does during the leave is everybody understands the fact that when somebody's on leave, they're treated as an active employee for benefit purposes, and they have reemployment rights, and that person who takes family medical leave cannot be retaliated against. So it's extremely important as an employer to understand what the significance of designating leave as family medical leave, and then understanding which employees are eligible. That's the challenge. So again, employers often find it challenging to keep track of their obligations under family and medical leave, and document as much as possible and communicate as much as possible to your employees so they understand what they have to do to qualify for family and medical leave. So again, but employers can avoid common problems by reviewing the top do's and don'ts, and that's what I'm trying to do here, is indicate to you what are some of the things you can do and what you can't do in dealing with family and medical leave. Now, the biggest challenge for employers in this situation is to create and consistently follow a family and medical leave policy. So because of the fact that family and medical leave is substantial and complicated, what you have to do is write down exactly what your policy is. Also, you have to check state law to see if there's any additional requirements that the state requires, either additional notice requirements, additional leave requirements, and that's important when you do your policy. So it must address coverage, which employees should do to receive family and medical leave, and what the employer will have to do in applying the family and medical leave, including record keeping. I think the biggest challenge for employers in this situation is to make sure they're notified when somebody does go on leave, make sure the proper notices are provided to the employees before they go on leave, and then what an employee has to do when they come back from leave, what rights they have and what the rights the employer has, and then what happens when they don't come back from leave. Because there are some things that an employer has to deal with if a person after their designated leave doesn't come back, with what the employee's rights are and what the employer's responsibility is going to be in the situation. So the Family and Medical Leave offers some flexibility in its application, for example, regarding paid time off. So employers will need to create a family and medical leave policy that complies not only with federal and applicable state law, but also existing employer policy. In layman's language, what I'm trying to say is you can force employees to take time off before the unpaid leave starts, but you have to basically communicate that to your employees. And I think it's extremely important to set policies, because the biggest issue and problem with family and medical leave is making sure it's applied consistently throughout all your employees. You don't want someone who is favorable and does a good job, goes on leave and gets preferential treatment as opposed to the other employees. You want to be consistent when during the application of family and medical leave. So again, once a covered employer has created a policy, it must be applied consistently. Failure to do so can contribute to lawsuits. And again, if you have a employee handbook, it is advisable that you put the details of your family and medical leave policy in your employee handbook. And I've seen where it can be 5-6 pages long and goes into detail. And this is what an employer can point to when an employee comes in and says they want leave, and then you have to go through the steps of determining whether that employee is eligible for leave, and two, what the employee has to do before they're designated leave. And so everybody understands what their duties are and what their responsibilities are, and so the employee understands what they have to do for that leave. Because, and you'll see this in the next few minutes, in talking to some employers, I'll ask the question, well, if somebody went on leave, this employee is otherwise eligible, why didn't you designate the leave as family and medical leave? And consistently I get the answer, well, the employee didn't ask for it. And one thing, and you'll see slides later in this, is not the responsibility of the employee to ask for the leave. It's the responsibility of the employer to designate the leave as being eligible for family and medical leave. But again, that's the employer's responsibility. The employee's responsibility is making sure they do everything possible and prove the fact they're eligible for leave. So again, do provide employees with proper notice. So family and medical leave applies to what we call covered employers. Private employers must meet this if they have 50 employees in at least 20 weeks during the current or previous year. And what's important here is the term previous calendar year. So if an employer dips below 50, they're going to have to comply with family leave for another year until it doesn't apply anymore. That 50 requirement does not apply to public agencies, elementary schools, and secondary schools. And under family and medical leave, one of the first responsibilities you have is covered employers are required to notify employees of their family and medical leave rights in two ways. First, employers should post a notice explaining the family and medical leave and how to file a complaint. And this posting can be electronic. And there's a copy of the notice that you have to post, or you can send electronically. And then second, employers should provide written family and medical leave information to employees. And employers should also distribute this information electronically. So this explains exactly what an employee's rights, and again, you should post it, but also you should send it to new employees. The Department of Labor has a sample poster and notice on its website, and that's the reference to where that notice sits. And again, as I indicated before, the biggest issue I have with employers, and for those who are not used to employees going on leave, is the fact they didn't provide family medical leave to an employee because the employee didn't ask for it, didn't say, as I say, the magic words. So employers should let employees know they may be eligible for family medical leave protection and not play gotcha in denying family medical leave coverage for failure to follow the employer's procedure policy. And again, in this process, what's important to understand is the fact there's responsibilities on each side. The employer has to communicate to employees and make a determination whether the leave is eligible for family leave, but in the same sense, the employee has a responsibility because they have to give notice of the leave, and then they have to basically return a medical certification that's completely filled out so the employer can make a determination whether the employee is eligible for family medical leave. The illness is enough to satisfy this. So there's responsibilities on each side. So if the employee doesn't complete that portion of the bargain, then the employer then the leave doesn't qualify and they don't have the protections under family medical leave. But again, both parties have to exercise their responsibilities. And again, the employer should also inform employees of their family medical leave policies. Now, again, don't fail to confirm eligibility. Failure to train managers to recognize when family medical leave may apply can place employers in legal, and this is the big issue with the DOL, and making sure, because all you need is an employee to complain saying, I went on leave and the employer didn't give me family medical leave even though I was eligible. So the employer's duty to the employees may extend as far as letting employee know that the family medical leave may apply. Employers should not interfere with the employee's family medical claim. And when employees make a family medical leave claim, the employer should not act or fail to act in ways that the court may later construe as attempts to stop or hinder the employee from making a claim. So, one of the things employer is don't tell the employees that they're eligible, deny someone a family medical leave because the fact if they didn't do X, Y, that maybe if the employee knew they had to do it, they would do it. So again, each party in this transaction has to exercise in good faith. The employer has to disclose what the rules are, what they have to do to comply, and inform the employees what the rules are, and then the employee has to follow those rules in order to make sure that they are eligible for the leave. That's extremely important to understand. Now, another mistake employers make, and this slide indicates this, is the fact that, well, we only deal with major illnesses, and that's not the case. The regulations say that the illness is anything that is 3 days or more would qualify for family medical leave. So don't make your call about what constitutes an illness. Surely a case of a flu won't qualify, but again, if it extends more than 72 hours, then in that situation, then family medical leave does apply. So, so a number of courts have ruled that an ailment like the flu can be considered severe because it can last for weeks. And if that's the case, then that person is basically would qualify for family medical leave, and you have to extend the protections to that employee. So that's extremely important to understand. Now, one thing that's extremely important to also understand is that the information on the DOL's website is pretty complete. They have a number of sample forms you can use. So the Department of Labor publishes sample forms on their website. Now, these forms are optional, but why recreate the wheel? Why these forms are optional. Regulations establish a safe harbor, so if you use them, you're safe. There's no question the fact that, but you have to make sure in using these forms, and this is the list of forms that you have, and make sure in using these forms the fact that they are completed by the employee and by the employer completely, and make sure all the blanks are filled out. So certification of healthcare provider for the employee serious illness, certification of the healthcare provider for the family member serious illness, a notice of eligibility, rights, and responsibility. This is basically you let the employee know what they have to do to comply with family and medical leave, and it tells them what they have to do. And then once that employee then qualifies, then there's a designation notice that the employer says, yes, your leave does qualify, and therefore you have all the rights and protections. Also, there's a certification for qualifying incumbency for military family leave, certification for serious illness for a service member, and certification of serious injury illness for veteran for a medical caregiver. That's where you can click on to get copies of these. And just be made aware the DOL just updated these. So if you've downloaded them in the past, maybe a few months ago, go in and click in again, because these the DOL just updated them just a few months ago. So get the most current versions of these forms, because every once in a while the DOL does update the forms. Now, one of the challenges of an employer, especially if you have a number of employees, is making sure your managers are trained to recognize when family and medical leave does kick in and when an employee could be eligible for leave. And one of the things that's frustrating for an employer is that one of your supervisors doesn't tell you an employee is left until a few days or a week after they've left. And so there are time limits of when these notices have to be given out. So you have to stress to your supervisors that you have to basically let the employer know as soon as possible if somebody is going on medical leave, and making sure you make a determination whether an employee is or is not qualified. So managers may fail to comply with the family medical leave in two ways. One is to take action or fail to take action while unaware of what the employer's policy is, and the other is to allow their emotions to govern how they act towards employees who claim or may be eligible for family medical leave. And that's the consistency argument. I think that you have to basically, we like Mary, and we'll bend over backwards for Mary. She's a good employee. She's having some family problems. Her child's sick, and we have to do everything possible to help her. But Ted over there, he's a marginal employee, and we're going to do everything possible to force him out, and we're going to make it tough for him to take any leave at all. That's where an employer can really get into trouble, because there's no good or bad employee under family and medical leave, as everybody has the same rights under this. So in both cases, training on the employer's policy and application is the best way to avoid mistakes and prove costly. And this is something I see time and time again with employers, making sure that the managers understand and the supervisors understand the fact that, you know, your personal feelings aside, if an employee is eligible, family and medical leave protection should be granted. So again, as I said, the family and medical leave does not consider whether an employee is good or bad. For managers, there may be a temptation to help good employees with navigating the maze of family and medical leave compliance, and to use the rules as a means to dismissing other employees. Another way that managers can create trouble for an employee is by failing to notify HR when family and medical leave may apply. I mean, and this is something that, because of the day-to-day operations, is tough to think about this, but I think this is something you should. The problem is that it's great to produce a huge handbook And it's bad if nobody reads it, including the supervisors, where they don't understand, or they don't really know what the employee's rights are in the situation and what the employer's responsibilities are. So the Family and Medical Leave also has confidentiality provisions that, if violated, can lead to a lawsuit. And this is, I think we're going to discuss this in a few minutes, but because we're dealing with a serious health condition, you have to make sure that any documentation involved with family and medical leave is kept private. The supervisor should not really know exactly what the cause of the leave is. I mean, they have a general idea, but the particulars should be limited to those in HR to make that determination. I mean, the initial the employee has to go to the supervisor to ask for leave, and then the HR should take over from there. So try not to share any particulars about this serious health condition that the employee may have. And again, if the employee discloses that information to the supervisor, I mean, they did it voluntarily. But again, you have to be very careful in these circumstances. And one of the issues, I think, here is you should stress to your employees, don't wait to tell HR that employee is on leave. There could have been an accident. It could have been, and again, family and medical leave, if somebody's on workers' comp, one thing that many people have a misnomer about is under workers' comp, yes, health coverage for their illness is extended, but if somebody is on workers' comp, it doesn't extend their health coverage. The only way health coverage can be continued as an active employee if that person on workers' comp also qualify for family and medical leave. So both workers' comp and family and medical leave are running concurrently. So again, you have to make sure that both avenues are met. And during family and medical leave, one of the best aspect of this is the fact that during family and medical leave, an employee is treated as an active employee. They only pay the active employee rate. If an employee on workers' comp doesn't qualify for family and medical leave, the only way that their health coverage can be continued is under COBRA. That means they have to pay the entire premium. So there's an advantage to make sure that employee qualifies under family and medical leave. So if a manager waits a week to inform HR that they could delay the start of the 12-week family and medical leave period, the employer generally cannot make family and medical leave retroactive, and letting the employer take more than 12 weeks affects staffing and productivity. Managers and supervisors, the fact it's important that we understand and we know when that person is off on leave, and make sure that the employee, again, meets all the requirements of notice of a leave and notice of time off. So there's no issue or problem of termination if they don't. And this is something, I think, leaves are something that employers always have a problem with. So again, management must initiate the family and medical leave process with HR right away, as soon as possible. So if that person is an eligible employee and they suffer from and there's an accident in that situation, two things that HR should really concern themselves with is the workers' comp claim, but also is that employee qualifying for family and medical leave, so they have additional protections. One factor that derails family and medical leave, the granting of family and medical leave, is incomplete medical certifications. And one thing as an employer, and there's two rungs of this that are extremely important. You don't have to accept a medical certification that is incomplete or unclear. To be good guys, sometimes employers sometimes accept certifications of a serious health condition that are incomplete or inconsistent. I think once you get that medical certification back from the employer, the doctor, make sure it's read completely and make sure that everything is consistent and complete. Because if the medical certification is not complete, and you go back to the employer, the doctor, and say, well, you want this completed, and they don't do that, as an employer, you can deny family medical leave. So this is an important aspect of it. So in particular, business sometimes make a mistake of accepting certifications that do not state the frequency and duration of intermittent leave that is needed. And this is something I think you have to get particular with, especially if someone has a chronic condition. What they can and cannot do, how much time they need off, I think has to be specified by the doctor. That's extremely important to get that detailed information to make sure that employees are not taking more leave than what the doctor asked. So you need particulars in certain circumstances. So it's good the fact that HR does review the medical certifications once it's returned either by the doctor or the employee to make sure everybody understands what everybody's responsibilities are. The employer understands, okay, because a medical certification is extremely important because it will determine how much leave that the employee needs, and the employer has to grant that if that doctor indicates they need, but there has to be information to justify that period of time that the doctor says that it needs. So if there's any questions under the regulations as an employer, what you can do is go back to the doctor and question them about their answers on the medical certification. That is allowed if it's unclear. So don't accept an incomplete or unclear medical certification, because that's the basis of granting the time under family medical leave. One of the dangers of family medical leave, and this generally happens if somebody with a chronic condition, when somebody takes off a period of time because of doctor appointments or treatments or whatever. And one of the biggest issues that employers have with intermittent leave is the fact that employers fail to keep exact count of how much time the employee took. This failure is highly dangerous, as this slide indicates. And generally, in intermittent leave, if you don't watch it, the employer might give an employee more family medical leave than he or she is entitled to, because it's too much effort to making sure that the employee actually takes the leave they're entitled to. They say they take 2 hours. Make sure that employee does take 2 hours for treatments. They don't come back in 4 to 5 hours. And it takes a lot of work in HR to do that, to make sure, and the supervisors to make sure that employee is not abusing the system. And with intermittent leave, that's a real challenge for employers in that situation. The even greater risk is that the employer counts some time as an absence that should have been counted as family medical leave. And the counted absence then plays a role in building a block or otherwise in the employee's termination. So again, employee has to understand the ramifications of taking more time, because they say, wait a minute, and so everybody's clear in this situation, how much time is that employee entitled to? Because if that employee abuses the intermittent leave, it could lead to termination. So the employer has to be very careful in this situation to make sure it's communicated what leave is going to be granted and what the consequences are in taking more leave than what is permitted. Also, make sure if you have a situation where an employee is rehired, making sure that family medical leave is available to eligible employees, meaning employees who have worked for the covered employer, have employed for at least 12 months and have worked at least 1,250 hours within the past 12 months, and making sure for that rehired employee, if you do rehire employees, that their past service is counted for eligibility for family and medical leave. And they have worked at least 1,250 hours within the past 12 months at work and a location where the employer has at least 50 employees within 75 miles. Many times employers have not done that. So again, with rehired employees, they can combine multiple periods of service to satisfy the 12-month requirement. For example, if an employer works 5 months in 2012 and 7 months in 2017, the employer would be eligible once he or she meets the criteria. So you have to have good records to make sure that any rehired person gets the family and medical leave they deserve. The only limitation of this rule is that the employer doesn't need to look back at previous employment that occurred more than 7 years before the employee was rehired. So again, if you rehire people, make sure HR understands that and make sure they count the past service for an employee that's been rehired. Julia, do we have any questions? I've been going on and on.
That's fine, Larry. At this point, we have opened up the question and answer box. So if you have any questions you'd like us to read live, happy to share those, and then we'll discuss any comments you have. My first question is from Aaron, and Aaron asks, what if the employee notifies the employer of their leave? We verbally say they are FMLA eligible, but the employee chooses to use PTO time versus FMLA. Is this permitted?
They can run concurrently. Because, see, the problem is if you don't designate the leave as being family and medical leave, they can take another 12 weeks sometime in the future. So it's in the employer's best interest to designate the leave as being eligible for family and medical leave, because that employee could come back from one leave, go on another leave, and you haven't designated that leave as family and medical leave. They have a right to another 12 weeks of unpaid leave. And again, you're just shooting yourself in the foot. So they can run concurrently. It's not one or the other.
Great, thank you. Those are our questions at this time. Everyone, please remember that you can chat in questions. I will read them aloud and Larry will answer them. Let's move on.
Okay, thank you. One of the misconceptions that employers have, and I run into this every so often, is that employers think that family and medical leave only applies especially for the employee if the injury or illness is work-related. That is not true. So some employers believe that employees may only exercise family and medical leave rights if they are hurt on the job. In fact, family and medical leave applies to any serious condition, meaning a condition that involves inpatient care or continuing medical treatment. And it doesn't matter when or how that employee was injured. And a fine example of that is chronic conditions. If one of your employees is under treatment for cancer or diabetes or some other chronic disease, that's a fine example where it's not work-related. And that's something that would be eligible for, especially if they are in continuous treatments for intermittent leave. So again, what everybody is used to, the fact that if somebody has a baby and in pregnancy, they get 12 weeks, or they have a serious illness, if they're in an accident, it's a block of time, 7, 8, 10, 12 weeks. More consistently and probably more frequently is the fact that somebody is taking family and medical leave on a small per hour basis for chronic conditions. That's probably where family and medical leave is more important, because it allows employees to take time off if they have to be, if they're under treatment. And this is one way of permitting an employee on a reduced schedule to be off. And again, it's a challenge for employers, as I indicated before, to make sure the employee only take the time they're entitled to.
And we've got a couple of questions, so I'm going to read these aloud. First question is, will a copy of the presentation and recording be made available? Yes, we will provide a copy of the presentation as well as link to the recording in the next 1 to 2 business days, so you'll have access to that. Now a question from Lauren. Can an employee refuse FMLA protection? And if so, can we make designating the leave as FMLA mandatory?
I think it's in your best interest. I don't understand why an employer would refuse. It's up to you. It's not up to the employee. It's not up to the employee that designates the leave. It's the employer that designates the leave. Because if the employee has a choice, it opens, as I indicated before, it opens the employer up to additional leave being granted during the year. And that's going to be a problem for scheduling. I think it's in your best interest to say, I'm sorry, but we're going to designate this, because family medical leave has additional, two important things is the fact if somebody goes on unprotected leave, the only way they can continue to get medical coverage is through COBRA. And they have to pay the entire cost of COBRA. Under family medical leave, they're treated as being an active employee, and so again, they only pay that 20 or 30% that active employee pays. The second and probably more important aspect of family medical leave is that they have reemployment rights. So under family medical leave, if that person comes back from leave and there's a spot open for them, you have to rehire them. If it's a normal leave, it's up to you whether you rehire them or not. So the job protections are there, and it's up to you, the employer, to designate the leave as being family medical leave eligible. Now, the employee could not cooperate and say, I want that not be family medical leave, I'm not going to comply. Well, again, the employee can do that, but is that an aspect of termination? They don't cooperate? I don't know. That's something you have to concern yourself with. Any other questions?
Yes. This one is from Anthony. If an employee is not eligible for FMLA, does the designation notice still have to be provided stating the FMLA leave is not approved?
Correct. You are correct on that. You have to inform the employee and the reason why the leave is not designated.
Great. Okay. Thank you for clarifying that. And then I've got a couple of questions, and I'm going to read 2 of those, and then we'll resume, and then we'll come back because I believe that some of these will be answered by your subsequent slides, Larry. So this one comes from Clarissa. How far back should we count previous service in determining an employee's eligibility for FMLA towards the 1250 hours?
Up to 7 years.
Up to 7 years. Okay. Terrific. And this question is from Cheryl. Per DOL's recent opinion letter, the employer must designate FMLA if they have sufficient information that the leave is FMLA eligible and the employee is eligible. If the employee refuses to submit medical certification, would there be any risk to the employer for not designating the leave?
No, that's one of the conditions. That's one of the conditions for family medical leave is you could refuse family medical leave if a medical certification is not returned. So you can, it's one of the conditions in receiving it because you have to verify the fact they have a serious health condition. And without the medical certification, how can you do that?
Thank you. And that was a similar question that Tamara had. How does an employer proceed if the employee does not submit the certification? So I think that
leave it. Now the next question is, it's up to your discretion whether to grant the non-family medical leave. It's up to you, the employer, to do that, but it sends a horrible message to the employee. Oh, I can manipulate the system and I can take other leave in the future if I just don't comply. And that sends a bad message to employees.
Certainly. Thank you. Those are our questions at this time.
Okay. Now, when you designate the leave as family medical leave, after the employee requests family, an employee responds with a designation note which explains the request has been approved. This notice typically advises employees that before returning to work, they need to provide a fitness for duty. Now, one thing to protect yourself, and what this slides indicate, is that
what you need to do is to attach the employee's job description or a list of essential functions. And the reason where you want to do that is the fact that you want to make sure that their healthcare provider understands what it will take for the employee to come back to work. And they can't understand that unless they understand what the employee's responsibilities are and what their job is. Because one thing you have to protect yourself against, if somebody is coming back early because the healthcare provider doesn't understand what their job is, and that person is still not 100% and they get injured on the job, and all of a sudden now you have a workers' comp claim. So to protect yourself is make sure that the healthcare provider in the because if one thing employers should do is before the employee comes back to work at the end of family and medical leave, you have to make sure that the healthcare provider understands when they fill out the fitness for duty is what the employee does, what their job is, what their limit, what they have to do, so they can say they can complete that fitness for duty form with full knowledge of exactly what the employer has to do when they come back to work. So again, what that does, and it gives, I think, that, now the provider's opinion on the fitness for duty form would be measured against a meaningful standard. And if the provider is unsure of the essential function of the position, they may rely on the employee's own report. For example, the employee could fail to mention lifting or driving requirements, in which case a fitness for duty certification may be inaccurate. So to protect yourself, you want to attach that and make sure you tell your employee this has to be given to the provider. So if you do return to work, they understand exactly what your job is. Now, one thing many employers don't understand is the fact that this medical certification has to be completed by a healthcare provider, must provide medical information. And the regulations indicate, and many employers think it's a medical doctor, but healthcare providers are defined as include clinical psychiatrists, nurse practitioners, physician assistants, Christian Science practitioners, and chiropractors. So again, all these individuals could complete, depending on the circumstance, could complete the medical certification. So don't reject a medical certification out of hand. Also, don't second guess a completed fitness for duty certification. So a fitness for duty certification expresses the opinion of the employee's healthcare provider that he can perform the essential functions of the position. In general, employers must allow employees to return to work once they supply a completed certification. So you've done everything else in the background. You've given the employee a job description, and the doctor says they're good to go. They can come back to work. The employer must contact the employee's healthcare provider to clarify or authorize the certification, but this communication should not delay the employee's return back to work. So if there's any questions, so you can go back to the provider and question them to make sure they had, I think, the complete information in completing the fitness for duty certification. Now, in this situation, employers cannot require a second or third opinion. If an employer believes an employee needs to be seen by a healthcare provider of the employer's choice, the employer remedy is to restore the employee to work and then arrange an examination if there's any question. Under the Americans with Disabilities Act, an employer may only follow the procedure if the examination is job-related and consistent with business necessity. So if they're an office person, it's different requirements than somebody working in the warehouse. Also,
Great.
to make
So
sure,
I'd
go
like
ahead.
to pause you right there. We've had several questions come in the meantime. This first one is from Maureen, who asks, um, is there a minimum chunk of time that can be defined as intermittent leave? For example, must use in 30 or 60-minute intervals.
Yes, there is, and I think it's either an hour or two. I can't remember offhand. I think it's an hour or two is the minimum. And again, that should be communicated to the employees. What's your minimum requirement? I think it's an hour or two, but I would have to check.
Thank you. This question is regarding retroactive leave. You mentioned that generally FMLA cannot be retroactive. Are there circumstances where it can be retroactive?
If the employee through retroactive designation could be harmed, then the retroactive designation cannot be used. And so the employer has to be very careful in retroacting leave in that situation, because if there's any harm involved to the employee by going back, then it can't be done. And so I haven't seen any cases in that yet, but you have to be very, very careful.
Good advice in any case. This question is regarding denial of leave. When the leave is denied, do you send the notice of eligibility along with the designation notice denying the leave?
I would send the designation notice indicating why that leave was not granted and why that person, because it basically what the designation notice says is the fact we're not designated because you're not otherwise eligible for these reasons.
Great, got it. Okay. This one is from Joanna. Where does the employer attach a job description or list of essential duties? Could you go into this just a little bit more detail? For example, is there a form the employer should attach to and request the employee deliver to the healthcare provider, or does the employer communicate directly with the healthcare provider? No,
I
color
think
there.
In the designated notice and also the rights and responsibilities notice, basically what you would do is indicate to the employee what their responsibilities are and indicate to them that they cannot come back to work unless the fitness for duty certification is returned to the employer before they come back to work. So that's a condition on reporting back to work. So at the beginning of the leave, all that would be given to the employee to make sure they understand that they cannot come back until those things are completed. So it's not sent. It's not sent later. It's sent at the beginning as a condition of the leave.
Mm-hmm. Very good. Timing. How much time? This is from Anthony, and this is regarding completed medical certification. How much time should the employer give the employee to return the completed medical certification?
The regulations say 15 days.
Great. And last question for now from Cheryl. This asks, will we be touching on joint employer relationships?
No.
Great, thank you.
It's all kinds of nooks and crannies, and I try to do it as much as possible, but we can't cover everything.
Great. Thank you for clarifying that. All right, let's move on.
Another aspect of it is don't require an employee to return to work without restrictions. So ADA requires employers to make an individualized assessment of when an employee is capable of returning to work. Most courts have concluded the same assessment is needed for family medical leave. Therefore, an employer's policies may violate family medical leave if they require employees to return to work without restrictions. And again, this is individualized, so depending on the type of business you have. So if you run a warehouse and people have to lift or carry things, you have to understand the fact that under what circumstances restrictions would apply. So if somebody can't lift or carry, what else are they going to do? So it's individualized with the job that employee has. So it's got to be realistic in that situation. So if they can't lift or carry as a restriction, what are they going to do? I think that's something, again, with each individualized situation. So for example, if a full-time employee provides a fitness for duty certification stating that she can return to part-time work, the employer must assess whether the schedule change would be a reasonable accommodation. And I think this is important because there's an interplay you'll see in the next few slides about the interplay between family and medical leave and ADA. Because the most common question I get about family and medical leave is that person is, again, at the end of their 12-week period, and they can't come back to work. So in that situation, once the family and medical leave is over, then there are two questions that the employer has to face. One, once that 12-week is over, then that coverage is terminated because of reduction of hours, and then that employee should be offered COBRA. Second of all, under what circumstance can you terminate that employee once they don't come back from family and medical leave? And what you have to consider in that situation is the interplay with ADA. Can you make any reasonable accommodation to that employee so they can come back to work? And that could be, again, part-time or other work, or 2 additional weeks of leave, which are not family and medical leave, so they can recover and come back to work. And that's a individualized employee by employee circumstance. And because if you don't consider that, in this situation, you see in this slide, other type of work or additional time, then an employer has concerned themselves with violations of the Americans with Disabilities Act. So be very careful in that circumstance. And it leads you to the next slide. So do consider whether to extend an employee's leave under ADA. Here, family and medical leave provides 12 weeks of leave within a 12-month period. Once an employee is exhausted, some employers believe the employee must return to work or face termination. Au contraire. This analysis overlooks the employer's obligation under ADA to make reasonable accommodations. Depending on the circumstance, it could be reasonable accommodation to extend the employee's leave beyond the 12 weeks. And again, the individual by individual circumstance. If you go back and you look at the end of the 12 weeks and that person is in a coma, they can't come back to work, there's no idea that they're going to come back to work in the next 5 or 6 months, that's a different situation. If an employee says, give me 1 or 2 additional weeks, I should be 100%. That's a different situation. Also, another mistake that employers make is don't count light duty work as family and medical leave. So here, employers often make a mistake of offering light duty to employees and not counting it, and counting it as family and medical leave. Light duty can be offered but must not be considered to be family and medical leave. For example, an employer can offer tasks that don't require lifting, or an employer who has hurt his back and cannot perform heavy lifting. If the employee wants time off, the individual is granted family and medical leave. So again, it's individual by individual employee that you. Now, one thing that's a challenge for employers is making sure they do keep records. So DOL provides some basic guidance to what records an employer must keep in relation to family and medical leave claims. Specifically, a covered employee who employ family and medical leave eligible employees must retain records that include basic payroll, identifying employee data, including name, address, occupation, rate of pay in terms of compensation, daily and weekly hours worked for each pay period, additions to and deletions from wages, and total compensation paid. Also, what's included is dates that family and medical leave is taken, hours of family and medical leave used if leave is taken in increments of less than a day, copies of any family and medical leave notices provided by the employer to the employer and by the employer to the employees concerning family and medical leave, and any documentation including electronic records describing employee benefits or employee policies and practices regarding taking or paid or unpaid leave. The reason why this is important is because if an employee complains to the local DOL office they were discriminated against and they weren't given their rights under family and medical leave, these records will prove the fact that you met those requirements as an employer and you gave the employee. And so the more records you have, including this, the more it can debunk what a disgruntled employee says. Also, what you must keep is premium payments for employee benefits and records of any dispute between the employer and the employee regarding the designation of leave, such as emails or other written statements regarding disagreement or designation of the employee's leave request. So again, anything surrounding the family and medical leave you have to keep to prove the fact that you met your requirements as an employer. And these records should be kept at least 3 years. Now, one of the challenges for employers in this situation, because what you're dealing with here is protected health information. So don't disclose private medical information about the employee. And this is extremely important, especially if their supervisor wants additional information about their condition. And again, you have to be very careful with what you disclose. Never disclose confidential medical information to anyone but the HR department or your direct report in the chain of command. Supervisors who handle family and medical leave requests learn about employees' medical problems. This information is private and you're expected to keep it that way. So keep a close circle around exactly who has disclosed that personal information, and especially the serious health condition that employee, because if you tell one employee, then it's all over the location and you run into problems that way. Also, don't retaliate. Many family and medical leave lawsuits address whether an employer retaliated against an employee for taking or seeking medical leave. If an employer disciplines, fires, demotes, or reduces an employee's pay or benefits after the employee seeks or receives medical leave, the employer should be prepared to defend the reasons for doing so. It doesn't mean that the employee has a free pass. It means if you're going to demote or fire someone, it's going to be for other reasons other than they took medical leave. So you have to keep complete records, make sure you can document the fact that why that person is terminated, because the first thing they're going to say, well, they fired me because I took 2 weeks or 3 weeks or 4 weeks off to take care of my child. My record is spotless. Well, you go back and you look and his record is not spotless. So it doesn't give employee a free rein to do anything they want. You have to document the fact of why that person was fired. And again, in circumstances where granting an employee a block of time is not feasible, under family and medical leave, covered employees may be eligible for reduced work schedules. And this is, again, intermittent leave. If, for example, an employee needs extra time in the morning to attend a sick family member but can work after that, the employer may consider altering the employee's schedule to accommodate the employee. Well, this sounds similar to accommodation provisions. This is completely separate than ADA, Americans with Disabilities Act. Family and medical leave covers serious medical conditions of the employer, or someone in the employee's family. Well, the ADA covers disability. So, and again, what it relates to is the leave, taking time off to take care of themselves or their family. So, family and medical leave does not allow employers some leeway with reduced intermittent schedule, for example, in case of fostering or adopting children. So it does allow them to do that. So you can be flexible in that regard if, again, it doesn't cause business disruption. Do keep in mind limitations on the employee's right to restatement. Now, what's important to understand in restatement, yes, if there's an opening for an employee upon the returning from family and medical leave, they have re-employment rights, but it doesn't mean they have complete if everybody in their class or their job grade got laid off, it doesn't mean they have greater rights. That just means they can't be discriminated against because of taking leave. So it's not a complete restatement. Now, employers with additional questions should consult the regulations, but even better, the fact that there's an employer guide to family and medical leave. It's on the DOL's website, and so if you have any questions, that's a pretty good guide of exactly what your responsibilities are under family and medical leave, and it's written in everyday language, so it's not technical, because some of the stuff can be, especially the regulations, can be overwhelming. So Julia, do we have any other questions?
We do. We have one additional question. This is asking, if an employee returns from FMLA, released to work half days, does the other half day still count to the 12 weeks of FMLA?
Yes, because it's additional leave. Now, in that
Because
situation, if they've taken the 12, here's the issue. If it's in addition to the 12 weeks and it doesn't qualify for family and medical leave, so that means additionally what happens is that person may not be eligible for medical coverage, so that because of the reduced schedule, yes, you allow that employee to work, but again, they're not eligible for coverage, and the only way they can get coverage is you offer them COBRA. So again, that reduced, outside of family and medical leave, that reduced time is at the employer's discretion, and the employer may grant that because it's adherence to the ADA.
Very good. Now I would like to launch a poll so that we can get some audience feedback, and also request that if you have any remaining FMLA questions, you chat them now. As you can see, the poll states, do you plan to evaluate your benefits administration partner? Describe your time frame. As soon as 2020 enrollment ends, or this year, plan to evaluate in 2020, will evaluate in 2021 or beyond, or no plans to evaluate. If you have a thought on whether that will be part of your IT or priorities in the year to come, we'd love your feedback so that we can help shape further webinar topics. We've received over 50% of feedback, and we'll give just another moment or two to respond to the question, and then we will close the poll. As an aside, it's hard to believe we're into 2020 and 2021 planning. Those years were far off a long time ago. And we're up to 60% of the vote. I'll give everyone just one more second to respond whether there will be some benefits administration planning in your future. And then we'll close the poll and move back into FMLA questions. So if you have any additional questions for Larry, this would be a good time to gather those and chat them into the question box. And I am now going to close the poll. Thank you for your feedback. We see that many of you are considering 2020 plans. Some of you will look as soon as enrollment ends or this year, and others have no plans to evaluate. So thank you for your feedback. We really appreciate it. I'm going to now read a question that was just chatted in. What if medical certification document is not returned in 15 days? Can we provide the employee with some sort of extension?
Sure. Sure. I mean, yeah. I mean, that's probably preferred. And saying, well, if let's say you have a situation where, and I've run into this, where you sent the medical certification for your doctor. He's a very busy person, and you come back, and the person comes back and said, my doctor's been real busy. He's out of town. He's on vacation. You know. And he'll return it as soon as he'll complete it as soon as he comes back.
employer in that situation should grant the extension. Give that person another 15 days. So yes, the regulations do provide an extension.
Great. And that is terrific. So some flexibility. Those are our remaining questions. No other questions at this time. I want to thank everyone who joined and stayed with us throughout. And I apologize. There's one last question. This one
Sure.
is from Laura. May an employee stay on company benefits while on FMLA or leave without pay, or should they be on COBRA?
Well, during family and medical leave, that person is treated as an active employee. So again, an employee has a right to either stay on benefits or to terminate them because there's a qualifying event. So while someone's on family and medical leave, they're treated as an active employee and they pay the active employee rate. Only at the end of family and medical leave would that person be granted COBRA.
Very good. Well, with that, we'll have that be our final word. I want to thank Larry once again for joining us. So helpful to have you review and discuss the do's and don'ts of FMLA. We appreciate your time very much.
My pleasure.
And to all of our participants, thank you for your time, and we look forward to providing you with more interesting webinar content. In the meantime, you can expect a copy of the recording and the presentation in the next 1 to 2 days. Thanks, everyone, and have a great day.